Hello everyone and Merry Christmas. When I was given 7 swans a swimming, I thought it would be the perfect opportunity to revise my performance of Swan Lake. Imagine my disappointment when I was told it had to be about planning law. Tempting though it is to provide an analysis of a recent case through the medium of my graceless and inelegant dance, I will stick to the traditional method of dealing with a case with a tenuous link to swans. Swan hunting is ill-advised in England and Wales, as they are the property of the Queen, but not in Orkney or Shetland, where, under Norse law, they are the property of the people. So if you're looking for a change for Christmas dinner, then hunt your swans in Scotland. And if you are looking for swans, you would be sensible to start your search at a lake. Which brings me to the case of Zinns versus East Suffolk. Mr. Zinns sought to challenge the decision of the council to grant consent for the creation of a lake for recreational activities such as raft building and canoeing. The challenge to the officer report was on the basis that it materially and seriously misled members about the advice of an environmental health officer with regards to noise, and also, separately, the heritage benefits through enabling development. The case helpfully restates the principles established in Mansell and Tunbridge. Officer reports are not to be read with undue rigour, but with reasonable benevolence, and bearing in mind that they are written for councillors with local knowledge. The question for the court will always be whether, on a fair reading of the report as a whole, the officer has materially misled the members on a matter bearing upon their decision, and the error has gone uncorrected before the decision was made. In this case, there were a very long list of concerns about the officer report that were raised by the claimant, 23 in total. The case had a long and detailed history. The judge found force in the claim that the officer report, which also included an update sheet, did not include all of the detail of the environmental health officer's advice and the full extent of his concern. But the question remained the same. Were members seriously misled? And the judge concluded that they were not. It is necessarily a very fact-specific case, but it is interesting as it provides observations on the considerations to bear in mind when challenging a grant of consent, which is essentially a challenge based entirely on the officer report. There is no requirement to repeat the consultation responses verbatim. The judge said that advice on planning judgment is a necessary part of an officer report and may include disagreement with consultee responses, in this case the environmental health officer. Just because an officer report could have been clearer, that does not make it unlawful. We also remember from Mansell and Tunbridge that the context of the report is important, and in this case members had carried out a detailed site visit, and they also knew that they could read the full consultation response online, and this is all part of the context. Finally, the judge said that the advice on the levels of noise was communicated within the report, and the planning officer writing the report and the committee making the decision can decide upon the weight of impacts that can be given in the balance as part of the decision-making exercise. Merry Christmas, everyone. I hope you all have a restful and peaceful break. Enjoy your Christmas dinner, but hopefully no swans.